Beautiful. Well, good afternoon, ladies and gentlemen, and thank you for joining us for our Australia and UK visa briefing. My name is Paul Wright, and I'm the Head of Commercial Partnerships for the Australian British Chamber of Commerce. First of all, may I thank the team from BDO for hosting us inside their beautiful offices today, and hosting us for a very topical subject. I think that everything that's going on in the near future will probably affect the majority of people inside this room, whether it's yourself personally or your business. We're also absolutely delighted that we're going to be hearing from one of Australia's leading immigration specialists, Maria Jockel. Now, I want to get your title correct because it's a very impressive title. Legal Principal and National Leader, Migration Services, BDO.
Thank you.
Beautiful, there we go, fantastic. Now, 10 years ago, I myself actually transferred out from the UK to Australia on one of those very 457 visas. I was very lucky towards doing so. 10 years later, I'm now actually a citizen, so you can't kick me out, so I'm here for good. God bless you. But the 457 visa has been an essential tool for businesses here in Australia in attracting and retaining global talent. The proposed changes will impact so many different industries, and it's great to see that we have such diversity of those industries inside the room today. We have people here from travel, infrastructure, finance, legal, education, and obviously the most popular industry for us Brits, recruitment. I think I was the only British person that didn't work in recruitment, to be honest with you. Now, one person, before we go on to the formalities, one person who definitely does not need to worry about visa is Prince Harry. You'll see where I'm going with this. And neither will Meghan Markle come Saturday for the royal wedding. Just a quick side note, we are going to be hosting a royal wedding dinner this Saturday with the Australian British Chamber of Commerce. And you will notice on your chairs as well, just a quick segue for the Australian British Chamber of Commerce, the rest of our events coming up, so we'd love to see you attend some of those as well. So ladies and gentlemen, please join me in welcoming Maria Jockel, Legal Principal and National Leader, Migration Services, BDO. Thank you.
Thank you very much. I was recruited by BDO to set up their law firm. It's a specialist immigration law firm in January 2017. And I think their decision was a very opportune one. They obviously had prophetic vision. They realised that Australia was an extremely vibrant economy, but one that was very concerned about the overwhelming demand for temporary and permanent entry to Australia. What I'm going to do is I'm going to canvass an enormous amount of ground in a very short period of time. I'm going to ask you to give me a bit of slack in doing so, because what I've done is I've gone above and beyond. You can go to many presentations. You will not get this volume of information. There are multiple brochures there which give you a snapshot of the new regulator and what we're dealing with. And then, of course, there's this PowerPoint which also tells you something about the new area of law. So let me move on. What the public don't seem to understand, nor does corporate Australia understand, is that we're dealing with a new regulator. The Department of Home Affairs is it's based on the British model, but it's on steroids. Minister Dutton is the Minister for both Home Affairs and Immigration. He now controls ASIO, which is the equivalent of MI5, MI6. He controls the Australian Federal Police, which is the equivalent of Scotland Yard, as well as the National Police. And in addition to that, what the Australian public and business do not know is that we have a dedicated police force just for immigration and customs. It's called the Australian Border Force. This is a completely different regulator. They control all aspects of immigration, and I'll tell you more as we go. So this is an extraordinary time in Australian history. It's a new paradigm. It's referred to as a once-in-a-generation change. A lot of the material that I'm giving you here is just contextual. Why do you want to know the context? Because information is power. I used to work in government. That was one of the first things I learned. Information is power. The ones that wanted to share some of the information were people that I considered to be very generous. There were a lot that weren't prepared to do so. Now, what the public don't know is that the legislation we work with is over 3,000 pages. We're dealing with 99 visa categories. Tonight we're going to do the 482 and touch upon the 186. The legislation changes constantly, and I mean constantly, and it's overlaid by policy guidelines which we purchase under licence, which in the industry are called LegendCom. They change constantly. The pace of change is so dynamic that they don't have time to change LegendCom because that's an online system. They send us newsletters to tell us that from now on the law is X, but the legislation hasn't changed and there are no official policy guidelines. You have to work in a very dynamic space, but this is the new era that we're part of. Now, why am I giving you the fees? Because the fees reflect the volume. The complexity is also reflected by the fact that there's a 39-page pricing table for visas. The Minister has said that in this new financial year he will make an additional $400 million from visa fees and fines. Who is the operational enforcement arm of the department? Does anyone know? The police force. I'm not here to intimidate you, I'm just here to give you data. Data is contextual, it tells you what a popular nation we are and why everyone wants to come to Australia. We are indeed a lucky country. All of this data is publicly not advertised. You wouldn't know that 34% of the 457s as they were then were refused, or that 30% of 186, which is the employer nomination, were refused. You see, the demand is overwhelming. You cannot cater to this demand, and it doesn't stop. It just keeps on coming, keeps on coming. So the 482 regime is intended to dampen the demand, and I'll touch upon some of the mechanisms that the government has created in order to dampen this demand, to regulate it what they consider to be more effectively, and so it better meets Australia's national needs and our economic needs. The projected increase in demand is also quite extraordinary. Last year we had over 40 million people enter this country. Think about it, we've only got 25 million people and about 12 million are employed. We're the size of America or China. Our population fits into the city of Beijing. What do you think the Australian public would think if they thought that there were 30,000 people trying to get into this country every day? We've already got 540,000 international students in Australia. 80% come with the view to staying. It can be pretty intimidating for the average Australian if they were to have this data. So what is the Department of Home Affairs all about? We're in the age of super information, data matching, digital technology, and the exploitation of data across the whole of government. Whatever you lodge with the department could go anywhere else within the government agencies, to ASIC, to Fair Work, to the Fair Work Ombudsman, to even Centrelink. Some of the data that you lodge could go to Centrelink because perhaps your workers are claiming benefits they're not entitled to, etc., etc. So increased use of biometrics. Why? Because there's a rampant industry of identity substitution, and there's a real concern as to who is who. Hence, even some Australians will be liable to have biometrics, to be subject to biometrics to prove their identity in certain circumstances. Now, this came from an internal document of the department on the 1st of July 2015. The then Department of Immigration and Border Protection provided its staff a number of internal documents, which I'm very grateful to have. But this really told you that on the 1st of July 2015, we were dealing with an agency that had transformed itself. And this is exactly their slide. Number one is in their people were Border Force, then policy and regulation. I've touched upon how extensive that is. Intelligence, of course, is your investigations. 40% of all intelligence comes from internal sources, so I'm told by some of their most senior investigators. Client services are the people who process your visas. They're at the bottom of the food chain. Enabling and support is your technology. The department is moving towards artificial intelligence, robotics. You are not actually anymore dealing necessarily with a human being. You're dealing with a machine which decides whether or not if you're going to get your visa. Again, this is from the same, a separate section of the same document. The concept of blended teams. Government has a wonderful way of using nomenclature. You've got to work out what it means, but embedded throughout the department, regardless of the scope and scale of the operations, what section you're in, are Australian Border Force officers. They could look like you and me, or they can have a uniform. Why am I telling you this? Well, I would imagine that if I was working inside the department, this would impact on how I make my decisions. positively or negatively. The Australian Border Force, they are the frontline. Now, this is actually all of the governments. This is not my language. This is taken from their own internal documents. I'm a purist. I stick to the facts. I'm not embellishing. I'm simply giving you the tip of the iceberg. It's very interesting because we've got a frontline operational border control enforcement entity, and they're responsible for virtually everything other than visa processing. Any of you who are 457 visa sponsors, you are monitored by the Australian Border Force. I'm currently dealing with Inspector so-and-so on behalf of one of our global clients. I'd like to tell you that they got the wrong end of the stick and they shouldn't be doing the notice of intention to take action. We will show that to them. But they are not your traditional police. They are basically police attached to immigration, and they work very differently. In any event, the age of reform. We are having constant reform, and the reforms that came into effect in March 2018, all of them intend, without any apology, to make it harder. So we've got changes as to age, employment history, salary, English language, eligible occupations, and it's look, that list is much longer. I could spend probably a whole day with you just giving you the tip of the iceberg as to what's changed. So this is a really skeletal summary. But we now have 3 new streams. You've got the short-term stream, the medium stream and the labour stream. Let me just explain to you. The government has decided that it's too easy to get into Australia and that they're concerned that you're going to take a job from an Australian, putting it colloquially. But that's unabashed, that's the fact. And so they've created occupations. The short list is generally not eligible for permanent residency. The medium to long-term list can be eligible for permanent residency if it remains on the list. And then the labour agreement is for those occupations where the minister and the department agree that you can recruit occupations which are on neither list. Now, we have a regional occupational list. We have a 187 regional occupations list. We have a regional medium-term list. We have these other lists. This is really complicated. What occupation are you on, what list, etc., and when will it change? We're just about to lodge a quality assurance manager, and overnight their occupation disappeared off the list. Now, occupations list, so it's not only enough that your occupation may or may not be there tomorrow, but it could be subject to qualifications or caveats. A caveat is basically a restriction, and there can be restrictions on the basis of 6 criteria. The person, the person who nominated the occupation, that's the employer, the nominee, being the visa applicant, the occupation, the position in which the nominee is to work, the circumstances in which the occupation is undertaken, and the circumstances in which the nominee is to be employed in a position. This is really complicated. This is a wonderful way to knock you out, even if you're a very credible corporate, because the decision maker makes a decision as to whether or how that caveat may work if your occupation is subject to that caveat. Now, fees, I touched upon it. The sponsorship and nomination fees have not changed, but look at what's happened in regard to the visa application fees. So you have different fees. For the short-term stream, look at what those fees are. So you could have a mum and dad and 1 child, and you're paying about $2,500 just in lodgement fees, but that's for your short-term visa, which generally will not give you permanent residency. Look at your longer-term visa. So $2,500 for mum, for dad, $2,400 for the mother, and of course any child who's less than 18 is $600. That is a lot of money to be paying just for a lodgement fee, and I'll touch upon the Skilling Fund Levy shortly. The Skilling Fund Levy on forward estimates is going to generate $1.2 billion in revenue for the Commonwealth. And basically, when it comes into effect, it's already passed the Senate, so it will come in at any time. When you lodge your nomination application, you will pay a levy depending on the turnover of your business, and it's paid according to the number of years that the visa is sought for. So it's a short-term visa, it's a maximum of 2 years. If it's a long-term visa, it's a maximum of 4 years. If you're a company that's got a turnover of, say, less than 10 million over 4 years, well, that's what, 4,800, or otherwise it could be 7,200. It's a lot of money, isn't it? That's on top of all other fees. So extensive. Are any of your companies here sponsors? Company sponsors? Read the new sponsorship documents. They are extraordinary. There's this new concept of anyone that's associated with you. It could be your mum, your dad, your accountant, your former company director, your current company director, etc. The level of detail and specificity that is required because of the fact that there's too many phoenixes. People come into the business, they do 457s, they get approved, then they get knocked out for criminality, fraud, exploitation, etc. And then that person or someone associated with them then sets up another company and repeats the same thing in a different guise. So this is intended, it's all part of data matching, it's all part of the digital transfer of information across government agencies. You must declare this, and then if anyone's associated with you, related to you, etc., they can then basically decide that perhaps you're not appropriate to be an approved sponsor. Sponsorship accreditation is about the only way that you can fast-track applications, and it's really the use of artificial intelligence and robotics, which I'll touch upon later if I've got a bit of time. Remember, I am rushing this, and any of these slides, I could have given you 50 just on that particular aspect of it. Adverse information is a very interesting concept. It's always been something that's been used against the visa applicant. Now it's equally available against the company. It has an extremely broad interpretation. The intent is not to intimidate, but to ensure that you are compliant. And if you're non-compliant, to have a lot of muscle in order to take adverse action against you. Before the Parliament currently is the Migration Integrity Bill, whereby once it's passed, the Minister can name and shame every corporation that's an approved sponsor that is paying their nominated worker less than what they told the department that they would pay them when they approved the nomination application. The Minister is exempt from any form of liability, so you cannot sue him. He's doing it in good faith. He will, of course, tell you that he's going to name and shame you. You will be given the opportunity to justify your actions, but at the end of that day, this is a concerted attempt to get the bad guys to do the right thing. It's a very strong end of the stick. Changes to sponsorship. Okay, well, the good news is that even if you're a startup, you can be approved for 5 years, and you can renew your sponsorship for a new streamlined process. Training benchmarks are no longer assessed, but if you're an approved sponsor, you still must have met your training benchmark requirements because that's a sponsorship obligation, and you could have the Australian Border Force take adverse action against you if you haven't. Accreditation criteria, I'm touching upon that very quickly, but basically, if you're a low-risk sponsor and they decide who's low risk, they keep data, they have risk matrices, your low volume usage, which is less than 10% of your workforce is from foreign workers. You fall within certain guidelines. There's category 3 and 4. You will find that there's extensive policy guidelines to interpret whether you fall into category 3 and 4. So just because you apply for accreditation doesn't mean you're going to get it. But if you do, you're going to be fast-tracked. We can get some applications approved within a matter of days. So it's a very good thing for high-calibre corporates. But if you do the wrong thing, then, hey, you've fallen from grace. The consequences are going to be pretty dire because then you're back into no man's land. And remember, the 457 and now 482 visa processing, some people are waiting for these visas to be processed for up to 11 or more months. And it's really disconcerting because you don't know where they are because your department is now nameless and faceless. You're dealing with the e-box and you don't know who you're dealing with. And you don't know the calibre of your migration agent. You see, all of this is tracked. And just by way of an aside, 5 to 20 people applied to become a registered migration agent in Australia. In less than 18 months, they registered 2,000 agents. Work backwards. Why do you think you generate that sort of revenue? You're not going to generate that from Marie Jockel's practice. We're far too conservative. Now, even if you're an accredited sponsor, the Minister has decided that some occupations are being overused and therefore some occupations will not be eligible for fast-track processing. It's interesting. it's interesting that, for example, accountants general will not be, etc. Management consultants, we work for a global management consultancy company, allegedly their people can't be fast-tracked. Why? If you look at these generic occupations, work backwards, it means that they're getting a disproportionate number of applications in that occupation. And you see what happens is they track the number of applications and the number of in which occupations, and that gets into the red zone. Remember, everything's data managed, it's digital, it's analytics. You're not going to know how many other applications of like occupation were lodged, so therefore you might find that you're in the wrong space, not because you're doing anything wrong, but because too many others are lodging the same occupation. So accredited sponsors, one of the good things, you may be aware now that everyone who lodges a visa application has to provide police clearances. If you're an accredited sponsor, you may want to give the client, your worker, a reference instead of a police check, but they must still provide their Australian Federal Police check. I would never advise any of my clients to vouch for their workers' police record. How can you know? That's a risk that the client would take. I certainly wouldn't take it on board. I would say to them, your workers should get their police checks unless you want to do something else in terms of risk management. So subclass 482 nomination applications. So the first part of the presentation was the sponsorship. And I've just skeletally touched upon the very significant changes that have been made in this regard. Then we go to the second step. So you're an approved sponsor and you're now lodging a nominated application in respect of an occupation which is on one of the, is either on the short-term list, the long-term list, or if you're an approved labour agreement a company on whatever the minister's allowed under the labour agreement, and basically then obviously the occupation, the position must be full-time, the person must have English language unless exempt. You will find that there's lots of exemptions and it depends on certain aspects of law. The nomination employment periods, so if you're on the short list, the occupation, you can be nominated for 1 to 2 years. But, for example, with the Australia-China Free Trade Agreement, it can be up to 15 years. You've got to look at the international trade obligations that Australia has. It's a level of complexity. We have trade experts working with us as part of our team so that we can actually claim whatever exemptions a client needs, and you may therefore have much longer periods of being able to retain certain workers than otherwise. Now, the medium to long-term occupations, that's your standard 457, as you remember. You could have that up to 4 years. But again, remember that they can go off and on the list, so that is a dynamic situation. Labour market testing is now generic. Everyone has to labour market test unless there's an international trade obligation which applies. So, for example, I'm acting for an Italian global freight forwarding company. We're going to bring in their one of their Italian directors to take a lead role in the Australian subsidiary. Obviously, we're claiming an exemption for labour market testing because of the international trade obligations. Now, he's a senior gentleman. We're also getting him an exemption on English language testing, etc. All of those things are doable. It's, as I said, you need to know this area. This is a bit on labour market testing, so if you're interested, you can have a look at that in your presentation. Every trade agreement is different, so you have to understand the terms and conditions. But let's say you've got to do labour market testing. It's now extremely prescriptive. Currently, it's 21 days. It's in order to get the Skilling Fund levy through Parliament, I understand they had to agree to now 28 days. And it's going to be, but you can advertise in the last 12 months, but if you lodge post 18 June, it's 4 months. You've got to have the ad, you've got to prove that the ad says all the right things. It's got to be a paid ad, it's got to be a number of ads, you've got to keep details of who applied, why they're no good, etc., to evidence that you're not taking an Australian job. So again, you can read these requirements in regard to these advertisements and labour market testing. Again, can I say say that this is simply a skeletal summary of many, many pages, not only of legislation, but also of policy guideline. It's very important that you're on all fours with both law and policy, and that your documentary evidence is infallible and evidences all of the above. Genuine position, this is a new concept. It's always been embedded in law, but now it's been articulated as a distinctive area of visa refusal. So basically your decision maker has a discretion to decide that regardless of the fact that you have got the skills that you have, etc., that it's not a genuine position. For example, does a local cafe actually need a chef, or is he a kitchen hand or cook? Does the local cafe need a restaurant manager, or are they actually just a waiter or waitress? They will look at the scope and scale of the business. There's internal policy guidelines on all of this. And obviously, if you can't show genuine position, even if you can, they have a discretion to refuse you. You can appeal to the Administrative Appeals Tribunal. You're waiting a couple of years. So get it right the first time. You don't want appeals. You want everything approved. And get credible advice. Is it doable? If it's not, we don't want to lodge. Because once you lodge, it's there. You could wait months and months. If it's refused, there you are. You've got something that is all sitting there. I don't like having things sitting there which is not something that's been approved. I am very, very risk adverse. I like to only work for the winners, and we make sure that we can assist people. So it is now unlawful to create a visa outcome because you want to give the person the opportunity to live in Australia. So how do you decide whether I've actually selected you, Nigel, because of your skills, or otherwise I really like you and I really want to give you the opportunity to be here because actually you and I are actually good friends? These are the sort of difficulties that you've got in this jurisdiction. But remember, go back to your numbers. The numbers are overwhelming and they're increasing. They're not going to decrease, they're only going to increase. So this is about evidencing genuine position, scope and scale, the breakdown of the business, the goods, etc., how the particular position is going to increase the scope and scale of the business, the productivity, etc., etc. If you read this in detail, it's actually quite minutiae. And if you really had to deal with all of this, hopefully none of you are such small corporations that you have to run the gauntlet of this, but it's pretty invasive. Non-discriminatory employment practices, I'm not quite sure how you'd prove that you're non-discriminatory, other than to say, look, we've got a minimum number of foreigners relative to Australians, but you know in the hospitality industry, they employ a hell of a lot of 417 visa holders, working holiday visa makers, etc., international students, because it's the nature of the industry. It's a very competitive industry. So again, this is something else that is a very interesting thing that they're highlighting to a much greater extent than ever before. It's always been there, but it's now been highlighted, and they can actually take adverse action against you if they decide that you're not, in fact, that you're discriminating in favour of a foreigner and against an Australian. English language requirements, well, they've been increased for the medium term. Now you've got to be 5 on all 4 aspects, but for the short term it's a minimum of 4.5 and an average of 5. There are some exemptions, obviously, if you hold certain passports and if you can prove that you've had a certain level of education of not less than 5 years full time. There are intra-company transfer exemptions, so it's very, very important that you understand all of these aspects, because you can actually make life a lot easier for your company by claiming those exemptions that are available to you. But it requires a sophistication of skills to understand all of these aspects of them. And of course, if the occupation requires a licence, then you've got to have the level of English that is required for that occupation. Nurses must have 7. Etc. Market salary rates. We used to talk about market salary rates. Now it's annual market salary rates. Why? Because they have found that the person on an annual basis didn't get the salary that had been promised in the nomination application that had been approved. So they're now looking at it on an annual basis. Then they're comparing it to what you pay your other staff, etc. It's a qualitative and a quantitative difference in the way that they look at it. But remember, you cannot be under that threshold of 53,900. And if you are recruiting staff at that level, you are potentially in the hot area. That's where you fall right into their risk matrices, where they're going to check you a lot more closely. They're now looking at contracts much more closely to ensure that you comply with all of these obligations. And they're looking at 3 separate aspects: annual earnings, and employment conditions other than earnings. Again, it's a lot more detailed than what it used to be. Relevant work experience. Now they've got to have at least 2 years relevant work experience. What do you think what impact is this going to have on international education? How many of your international students are going to have at least 2 years relevant work experience when they want to come to you for a 482? Unless, of course, they've done a master's or a PhD or additional work placements. There are exemptions. There's policy on exemptions as well. But will you get through that exemption? That's the question. Okay, so this is in the past you could be an unlawful and you could still apply for 457. Now they've changed that. This is really a technical issue. It's only relevant if you've got a worker in this circumstance. You ought to get advice on these matters on a case-by-case basis. It adds a level of potential complexity. And then skill assessments. Basically, the government has extended the occupations and the passports that require mandatory skill assessment. It's, again, a mechanism to ensure that only people with a certain level of skill are able to get their to qualify for the visa, rather than the purported level of skill, because people will assert this. They will say that they've got these qualifications and skills, they'll provide work references, etc. Well, a skill assessment requires you to be put to your proof, because you are assessed by a body which is authorised by the Department of Home Affairs, and therefore you can assume by that whatever their website says, they will be extremely conservative. Don't assume that just because you read it on a website it's going to happen. Websites are simply information, and information changes constantly, as does the policy behind that information. So this is a bit on skill assessments. I'm not going to touch upon that tonight. There are exemptions to skill assessments. Again, I've talked about exemptions earlier. So it's a really interesting time, because you've got 457 visa holders and they're going to transition to a 186. You've got to see what exemptions there might be, because there's certain changes. So it is a very, very complex area of law. I believe that immigration is a bit like a maze. It's like a labyrinth, and if you know your way through the labyrinth and you constantly get out, then you've got intellectual property. Okay, that is a commodity. Genuine intention. The case officer, on top of genuine position, they can decide whether your work actually has a genuine intention to work in the position. How do you decide whether you, Nigel, are actually genuinely going to work in that position? Well, you are. They can decide that. Okay? They may assume it, but they can also get intelligence on it. Who gets their intelligence? Obviously the Australian Border Force. Do you know? No. You're not told. Even if you've got a migration agent and they've lodged a 956, you will not be told about any inquiries that they're making in respect of any aspect of an application, including as to whether the file is transferred overseas, which is the country of your origin, to verify some of the aspects of your application, which is increasingly done. The skill level obviously has to be consistent with ANSCO. ANSCO is the Australian-New Zealand Standard Classification of Occupations. It's a statistical textbook which is being used by immigration, and it determines which occupations are eligible to be used for the 482 visa. And then you look at ANSCO, and that gives you the indicative skill level. Remember, your position descriptions have to broadly accord with the ANSCO code that you're nominating the worker for, but they cannot be a direct copy. Obviously, that would be suggesting that that this is a charade of some sort or other. Health requirements, again, for those that may have any of those issues. I won't touch upon that tonight, but that increasingly we work with a lot of people who've got health issues, and our job is to help them through the process, be it temporary or permanent residency visa. There's some new conditions that they've created. The condition 8607 is the equivalent of what you used to have an 8107. You can only work in the approved. You can only work in the approved work. Be very careful. Not lower duties, not higher duties. You've got to do what you said to them, because they do not want you doing what you want to do. It's not appropriate. They're wanting to control what you're able to do in Australia, and you've been approved on a particular basis. Increasingly, there is condition 8303, no involvement in disruptive activities. And remember, all applicants for these visas must comply with the Australian Values Statement. So if your worker gets themselves into some spot of strife, you may find that they get their visa. Their visa is at risk because there's this perception that Australians are very law-abiding and we don't want to import any people who are not, if you know what I mean. Anyway, that's just a little bit of fun. Visa cancellation powers have been extended significantly. The Minister's also increased his powers in this regard. So it's very, very important that you consider. I've been asked by a corporate that's management consultant. He's on about 180,000. He's applied for a 186 direct entry. He's a 457 visa holder. They've got to post him overseas for 6 months. We're immediately saying, well, hang on, is he going to fall foul of the genuine intention to perform the approved nominated occupation, because he's going to be overseas for a long period? In that context, you've just got to be very careful that a case officer doesn't get the wrong end of the stick. How am I going for time? Probably, I'm talking awfully fast, Paul.
You're going fine.
Oh, good on you, thank you. All right, well, I'll take a breath. The 186 changes, I've simply summarised these. They are very extensive. You've got the 186 changes, you've got the 187 changes. So the 186 is the employer nomination, permanent residency visa. The 187 is the regional version of that. And then you've got what's called the TRT, the Transitional Residence, Temporary Residence Transitional Stream. That is for current 457 or 482 visa holders, unlikely to be 482, but there are certain things that the Minister can and cannot do. I'll give you a scenario. You're a 457 visa holder. You got through the system swimmingly. Your employer now sponsors you for a 186. You've already been with the employer for 2 years. Historically, that was a shoo-in that you would definitely get a 186. No more. Remember, I gave you a bit of data earlier on that as of last year, they were refusing about 30% of those. What the Minister now can do is require you to have a skill assessment. In other words, despite the fact that you've been in the same nominated occupation, working for the same employer with the same set of credentials, there is some concern as to whether you indeed had those skills, as a result of which your visa was first granted. So you're put to your proof. Now, these are all things that a case officer can do, and there's more and more and more of them. I'm just touching upon some of them. Now, obviously, if they hold a licence, they've got to be evidence that, there's a lot of changes to do with whether, if you're on a 186, say that you're on a temporary. On a 457 visa, you've been with the employer, your visa was granted to you post 18 April 2017, or you applied pre 18th April 2017 and the visa was granted to you, you will find that until the 18th of March 2020, people in these circumstances will be subject to what we call transitional arrangements. And transitional arrangements mean that there will be certain exemptions. So the hurdles that the new people who have had a 482 approved and want to go to permanent residency will not be there for you in the same measure. Give you an example. If you're on a 457 and you're approved at that time, you're going to 186 temporary, TRT, you only have to be with your employer for 2 years. However, if you're a new 457 visa holder and you're on the long or medium term list, because you're not going to get permanent residence if you're on the short term list, and you must be with your employer for 3 years. Why is that? To dampen the demand. So it goes on. Now, I'm very much cognizant of time, and I'd love to know as to how I'm tracking, because I was told that we need to leave lots and lots of time for questions. So am I okay to continue on with this? 5 minutes, thank you very much. Can I just touch upon that the 186, 187 TRT, that's your fourth point down, nominator occupation must have the same first 4 digits of the ANSCO code. It is very important when a worker's with you for some years for you to not change their duties in such a way that they are no longer in that ANSCO code, because you can unwittingly disentitle them from being eligible to make their permanent residency application, but you could also put them into a situation where their visa could be cancelled, because all primary 457 visa holders' visas are granted subject to condition 8107, which means that they could only work for you in that approved nominated occupation, and it's that 4-digit code. Now, because there are hundreds and hundreds of occupations, you could easily, inadvertently, by virtue of a change of position, duties or title, etc., find yourself that you're actually getting your worker to do something which has not been approved. So when we act for employers in respect of 186 visas, we ask them to give us the position description at the time that they lodged for 457. We then match that against what they've given us for the 186 to see if there's any variance, to see that there hasn't been any inadvertent change which is not permissible. That's called risk management and quality assurance. Generally performs, obviously, the 186 and the 187 are temporary. The TRT actually now has a genuine position requirement. So your worker says to you, well, I've been with you for 2 years on a 457, I want you to do a 186. They assume that they will definitely get the 186. Do they know that you have to establish that that's a genuine position, that you genuinely intend to perform that occupation in that position? And if you look at the policy guidelines as to what they can look at, the policy guidelines actually also, if they want to put you to the proof, and I'm not telling you that they will, but this is just the armoury of powers that they have, they can actually ask you to establish what loss you will suffer if that 457 visa holder was to depart Australia. That level of specificity, it is extremely invasive if you're unlucky enough to be at the pointy end of the stick. And if you do get what's called a Section 56 notice or a request for further information of this kind, I would suggest that you assume that you've got issues. Okay? Because a request, I know that people say, look, it's just a request for further information, but why was it instigated? They could have just pressed approved. And remember, what you lodge will then be checked against everything else you've ever provided to them to ensure that there's no inconsistencies or errors, because one of the things that my slides don't talk about is public interest criteria 4020. Has anyone heard about that? Basically, any false or misleading information, any bogus document, even a super embellished CV, can result not only in visa refusal, but also for that worker and everyone included in their application to have their visa refused and to be barred from reapplying for 3 years, which in effect means a permanent bar, I would say, in practical reality. Anyway, moving forward, I could go on and on and on. They are very extensive changes. Now, what am I doing? Hopefully it's moving on. Okay. I'm not going to say anything much more about this. Look, again, these are extensive. One of the interesting things now, of course, is as from the 1st of July 2017, you need IELTS 6 in English. That's quite a nice jump. The good thing about the new laws are, as of the 18th of March 2017, that if you had a 457 visa in that magic period of the 18th April 2017, You will be able to meet the age exemption requirements as long as you meet the Fair Work High Income threshold requirements. That has been retained, so that's a very good thing for older workers. Can I also say to you that I have really got great concern about the number of applications that are lodged as a 186 direct entry. A direct entry means that the worker does not have to have been with you for any period of time, be it on a 457 visa or otherwise. It's open to the world at large. So you could have a worker in the UK and you could decide you want to give them permanent residency just like that. Don't you think that our government might wonder why you're wanting to fast-track somebody's permanent residency? Because when they arrive in Australia, they may decide to take another offer. But people assume falsely that, well, I want permanent residency as quickly as possible. I've got wonderful skills. I want to stay with you as an employer. I want you to fast-track permanent residency. The indicative processing times for permanent resident, the direct entry, are up to 15 months, much longer than the 186 transitional entry stream, and that's a decided strategy of the government, and a significant number of the direct entry are being refused, despite the fact that they require skill assessment in order to be eligible to make the application. So it doesn't matter that the skill assessment has been done. They will find that if they want to, they will refuse you. Last point about 186s, 187s. These are subject to a quota. The quota is absolutely strict. You cannot have one number more in a financial year, whereas the 482s and the 457s are ostensibly demand-driven. But, hey, the demand is so great that we're now dealing with a whole new area of law which builds upon what... This is all fundamentally consistent with 457s. I had the privilege of writing the textbook on it, so I know. But it's taken to a new level because there are many more hurdles to jump in order to be able to be assured of getting your application through. Now, you might say, Maria, does carry on. Well, the situation is this, that our business model is that we don't get things refused. So we're at the premium or exceptional end of the market. We put an enormous amount of effort to our clients. You can't get half a visa. And we know that if you have to go and appeal to the AAT, you may be waiting 2 years, which is actually a deal breaker for most corporates. So obviously your effort goes into primary decision making. And of course we compete with a very congested immigration market. So I'm going to stop here and just quickly touch upon the conclusion. This is a very curt summary of a very extensive range of changes which are exceedingly complex and have many aspects to them. The aim is to allow Australian businesses to continue to access foreign workers, the skills that we need, but it's much more targeted and it's much more dynamic. Occupations go on and off the list. They could be subject to a caveat or not subject to a caveat. And always the emphasis is on protecting Australian jobs, hence labour market testing requirements, unless Australia's international trade obligations prevent the government from putting that into place. These changes are also intended to bring in a higher quality of foreign worker, and for the economic contribution of that worker to be much greater than we've known historically. This is a concerted public policy of the government, and coupled with that is the extraordinary expansion of the department's powers and reach. I never thought that I would work in an area where predominantly I'm pitching to what could be potentially a police force, because I don't want any of my clients to be monitored by the Australian Border Force. That is not the risk space that we are in. So I would urge you to continue to take advantage of Australia's skilled temporary and permanent entry visa programs. They're here. Australia's a tiny nation in a vast sea of the globe. It's competitive. This is just a measure to try and dampen the demand, to ensure that the eligible people that under the new criteria get in, and to also give the department the opportunity to refuse those that it wants. We are now increasingly dealing with artificial intelligence and robotics. If you're an accredited sponsor, you will find that often your application has not actually been dealt with by a human being. It can't be. I've lodged one today and within 24 hours it was approved. Well, you cannot allocate a case to a case officer in 24 hours. A machine decided that we fell within all of the tick, 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 tick boxes, and voila, application approved. And that's where you want to be if you need to meet your international skilled workforce needs. That's the ideal. Thank you for your listening.